Good evening, everyone. I'm Professor Michelle Foster. I'm the Dean of the Melbourne Law School, and it's my great pleasure to welcome you to the 2025 Alan Hope Southey Memorial Lecture. I'd like to begin by acknowledging that we are gathering this evening on the unceded lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to Elders past, present and emerging, and extend that respect to any Indigenous colleagues with us this evening. Well, it is an honour to welcome you to this special evening in the Law School's calendar of events. This lecture tonight honours the Southey family and recognises not only the contribution to this law school of Alan Hope Southey, but honours Alan's wife Nancy Southey's gift to the University of Melbourne and her subsequent law lecture sponsorship since 1958. Alan Southey was a 1917 Master of Laws graduate of Melbourne Law School who died in 1929 at the age of 35. But the Southey family has continued to honour his legacy through their continued support of the law school and of this lecture series, and I'm delighted that we can continue that tradition this evening. I'd like to acknowledge in particular that the grandson of Alan Southey, Rob Southey, is joining us tonight, as is Pip Southey, Rob's niece. I hope I've got that relationship right. Welcome, Rob and Pip. It really means so much to us that you are here with us this evening. It is a pleasure to introduce our speaker for this evening, Professor Lucina Ho, the Harold Shao Wo Lee Professor in Trust and Equity at the University of Hong Kong, to present the Alan Hope Southey Memorial Lecture on the topic, Breaking Trust Law Boundaries for Impact Investment. Professor Ho is a leading figure in the field of equity and trusts, having taught and published widely in trusts, equity, unjust enrichment, comparative trusts, and elder and disability law. She serves on the editorial boards of the Journal of Equity and the Oxford Journal of Legal Studies, and she has consulted for the Chinese and Hong Kong governments. Recently, Professor Ho was pivotal in establishing a public trust service in Hong Kong for people with different abilities. Before I invite Professor Ho to the podium, I'd also like to acknowledge my colleague, Professor Ying Lu, who will moderate the Q&A at the conclusion of the formal presentation and also offer a vote of thanks at the end of the evening. Professor Liu is an Associate Director of Private Law at the Asian Law Centre here in the Melbourne Law School and founder of the Asia Pacific Trust Law Project, the first initiative to assemble an Asia Pacific-wide community to discuss trust law issues. Just to note, this event is being recorded and a recording will be available on the Melbourne Law School website shortly. But for now, please join with me in welcoming Professor Lucina Ho to the podium. Thank you.
Thank you, Michelle, for the kind introduction. I would also like to acknowledge the traditional owners of the unceded land on which we meet and pay my respects to the elders past and present. I am deeply grateful to Andrew, Ying, everyone at MLS, and colleagues from other law schools for such a warm welcome. My special thanks go to the Southey family for their generous sponsorship of this evening's lecture. It is truly a privilege to be with you all this evening. When you saw the title of this lecture, you might have wondered what trusts, those vehicles used for tax planning, have to do with impact investing, which aims to make profits while doing some good for the world. This evening, I hope to share with you not only how these two worlds connect, but also how trusts could open up powerful ways to support impact investing. These findings stem from my broader project to reshape trust law for social good. Let me start by setting the scene. Of the key challenges facing us in the 21st century, wealth inequality is perhaps one of the most pressing. A UBS study in 2023 showed that the world's richest 1% now holds nearly half of all global wealth. Adding to this is the problem of intergenerational inequality. Just recently, The Economist suggests that inheritocracy is supplanting meritocracy. We might as well teach our children how to manage their inheritance rather than fret about their university entrance exam scores. These 21st century challenges raise two important questions about trusts. First, whether trusts remain legitimate legal devices. And second, if they are legitimate, whether trusts can help address the world's contemporary challenges. I shall examine both questions, beginning with legitimacy. To be frank, trusts originated in evasion. Medieval landowners, used them to bypass the primogeniture rule, which says that the eldest son inherits all of the father's land. Landowners would transfer land to trusted friends to hold it for their chosen beneficiaries, including illegitimate children who could not inherit. The discretionary trust, now the predominant form of trust, emerged in the mid-20th century in response to the punitive taxation rates introduced by governments after World War II. These trusts granted beneficiaries mere expectations of distributions, rather like children hoping to get a slice of a cake. Such arrangements ensure that the beneficiaries have no vested proprietary interest in the trust assets that creditors or tax authorities could reach. Discretionary trusts, now the predominant form, skip the slide a little bit too early. Discretionary trusts, now the predominant form of trust, emerged in the mid-20th century. Going back. So discretionary trusts have not escaped judicial criticism. Lord Justice Harman was forthright in the famous re-Londonderry case when he said during the hearing that, quote, "I think a discretionary trust is a mere fiscal dodge." A decade ago, Sir Anthony Mason also observed extrajudicially, quote, "It has been widely recognized that discretionary trusts have been a popular means of avoiding tax. Yet tax planning tells only part of the story. Since a discretionary beneficiary's entitlement, indeed whether they receive any distribution at all, rests upon the trustee's discretion, discretionary trusts are actually very powerful instruments for behavioral control. In recent decades, we have seen the emergence of increasingly aggressive trust structures, leading to an ongoing game of cat and mouse between practitioners and regulators. Much of this development has been driven by competition for business. These structures fall into three broad categories. The first category, what Lionel Smith calls massively discretionary trusts, weakens beneficiaries' rights almost to nothing. In such a trust, the trustee can add or remove beneficiaries, but have no duty to distribute the whole estate to them. So this creates a pool of objects of power who lack proprietary interest in the trust property, whether individually or as a group. And without proprietary interest, they were traditionally thought to lack standing to enforce the trust. To give the appearance that there is a beneficiary, the trust also typically names a charity, like the Red Cross, as the residuary beneficiary without informing them. So the only party with standing to sue won't take the trustee to court because they're kept in the dark. And instead of beneficiary oversight, the settlor would appoint their trusted protectors to monitor the trustee. However, the roles of protectors can vary widely, depending on how the trust document defines their powers. Further, courts remain divided on whether protectors, in exercising their powers of consent, should have a wide power to act on their independent discretion, or only a narrow power to merely ensure that the trustee's decision was rational and within the scope of the trustee's power. The second type keeps a small discretionary class of beneficiaries, such as the settlor's family, but reserves excessive powers to the settlor. In extreme cases, such as the trust settled by Mr. Pugachev, once Putin's close friend, the settlor is the sole trustee and had the power to unilaterally replace all beneficiaries with himself, without any fiduciary constraints. the English High Court held that these powers effectively allowed him to retain the full beneficial interest in the trust property despite purportedly creating a trust. And as a result, his creditors could make claims against the trust property. In Clayton and Clayton, the New Zealand Supreme Court treated similar powers in a family trust as property available to the settlor's ex-spouse in divorce. But the same court reached the opposite conclusion once the powers were dialed down just a bit, as in Cooper and Pinney, a very recent decision of the same court. There, these powers must be exercised unanimously with at least one co-trustee in the beneficiary's interest. Mark Bennett and Adam Hovry-Winograd argued that this very minimalist scrutiny overlooks how easily trustees can collude against the beneficiaries, and I agree. In fact, in Cooper and Pinney, the other trustees were the settlor's sister and someone who is most likely his friend, so it's not easy for the three of them to put their heads together. The third type, non-charitable purpose trusts, does away with beneficiaries altogether by granting standing only to enforcers appointed in the trust deed. Take the Cayman Island Star Trusts, which often have empty stated purposes, such as to hold the shares of a company. Now, this really just tells us what a trust does, and that is to hold property on trust, rather than what it's meant to achieve. Making matters worse, national legislatures are unlikely to rein in these excesses. Why? Since professional trust services are mainly for the wealthy, the general public has little interest in pushing for reforms. The trust industry ends up dominating these discussions, lobbying for more relaxed laws to attract business. After all, where there's money to be made, people will find a way. One only has to look at the much touted league tables ranking the best, or rather most accommodating trust legislation in US states, as in this website, to recognize the alarming race to the bottom. So what do we make of these developments then? We must recognize that not all trusts are there to do bad. Well, one approach, one might say, is to say that it is natural for concepts to evolve. Take the word computer. Just a few decades ago, it actually referred to people whose job it was to compute, just like typists whose job it was to type. Here is a picture of computers at NASA in the 1940s. Now we think of computers as machines. So concepts do evolve. However, when changes strip away the fundamental features of trust, the transformation is rather like Anakin Skywalker becoming Darth Vader. Another approach is to rewrite objectionable trust terms. Hanot Dagan and Irit Semet have urged courts to order trustees to appoint the discretionary objects as named beneficiaries, thus, in their words, transforming these ghost beneficiaries into real ones. However, I have doubts about this proposal. It seems counterintuitive to use equity's supervisory jurisdiction, which is designed to protect the interest of beneficiaries, to mandate actions that would undermine those very interests. I propose a third approach. We need to fundamentally rethink our outdated conception of trust. Doing so would help us define its proper boundary and strengthen its enforcement. This involves accepting three propositions. First, to establish the legitimate role of trust in society, we must examine its theoretical foundation. Trusts are one of the main legal forms in society, alongside contracts and corporations. And like any powerful legal tool, its value is independent of how it is used, just as nuclear technology can be used to power cities as well as to destroy them. So with this distinction in mind, and this is a distinction between form and use, Matthew Harding and I have suggested that the greatest value of trusts lies in their role as governance frameworks that support people to commit their resources to valued goals and individuals. We cannot simply just assume that anyone who uses a trust is using it for bad purposes. Trusts actually offer the strongest commitment device available in private law, surpassing contracts, agencies, and corporations. Think of Rupert Murdoch's so far unsuccessful attempt to modify his family trust to strengthen his son Lachlan's control over his business empire. Similarly, in Granville and Wong, a Privy Council decision, the court held that the purpose of a trustee's power should be determined at the creation of trust, such that the settlor's subsequent wishes about how to exercise the power was not admissible evidence. So put shortly, Mr. Wong, the settlor, cannot change his mind after setting up the trust. When we view trusts as governance frameworks rather than just property arrangements, a breach of trust isn't just about interfering with property rights. It is also about violating the rules of governance that protect the distribution of these rights. This leads us to reconsider the nature of the beneficiary's interest, which is my second proposition. Traditionally, lawyers have described beneficiaries as having equitable interests attached to the trustee's legal estate. Sir Anthony Mason noted in DKLR Holdings and Commissioner of Stamp Duties that, quote, an equitable interest is impressed upon the legal estate. Now, this characterization was echoed throughout the judgments of the recent UK Supreme Court decision in Byers and Southey National Bank, although Justice Leeming has critiqued this case reasoning extrajudicially. Such traditional thinking creates the impression that the equitable interest is somehow stapled to or engrafted upon the legal estate. There's an alternative conception. Ben McFarland and Robert Stevens suggested a more nuanced one, and that is that beneficiaries don't have direct rights to the trust property, but rather rights against the trustee's rights to that property. And Larissa Katz calls the beneficiary's rights pathway rights to trust property. While this newer view is illuminating, it still misses something crucial about trust as governance, in my view. Beneficiaries' interests aren't merely about controlling what trustees do with trust property. They are much broader than that. They include safeguarding against trustees' exploitation of the fiduciary relationship. Consider the fair dealing rule, which prohibits trustees from purchasing the beneficiary's interest in the trust. When trustees do that using their own funds, they aren't misusing trust property, they are abusing the fiduciary relationship. And the right against rights thesis does not address this rule because it focuses on the trustee's powers over the property only. I therefore propose that beneficiaries have a bundle of rights that both regulate the fiduciary relationship in a trust and control the trustee's exercise of powers over the trust property. My third point, standing in trusts. This naturally follows from my second point. And if you agree with my suggestion of not viewing beneficiaries simply as equitable property owners, we should also see them as participants in a governance regime supervised by courts. When beneficiaries or objects of powers enforce trusts, they support the court's role in ensuring proper trust administration. On this view, whilst those with vested equitable interests clearly have standing, we shouldn't deny standing to objects of a power just because a trustee hasn't yet exercised discretion in their favour. Indeed, precisely because their potential interest deserves legal protection, that we should give them standing. On this point, Jessica Hudson has demonstrated that Australian courts have had no difficulty recognising the standing of objects of power. This raises a crucial question. If not an equitable interest, what rights do these objects have during this period of anticipation that justifies giving them standing? And what relief can they seek? Here again, Australian courts are ahead of their brethren in other jurisdictions because Australian courts, and some scholars, actually articulate this right as one of due administration. I think this is very, very close to the mark. I just propose a slightly more precise formulation. The relevant right is a right not to be unlawfully excluded from potential beneficial entitlements. To elaborate, this is a right against the trustee, namely that the trustee complies with the terms of the trust so as not to unlawfully exclude the beneficiaries from trust benefits. An apt analogy might be children awaiting gifts from Santa's sack. Although the children have no right to receive a particular gift, they have a right not to be wrongfully excluded from the possibility of obtaining a gift. And just as destroying the presents in the sack would wrongfully exclude the children from potential gifts, the unauthorized disposal of trust assets remove property that should have been available for distribution. Two features of current trust law confirm my proposed formulation. First, when a discretionary object successfully recovered trust property, such property would be returned to the trustee for ongoing administration according to the terms of the trust, rather than going to the plaintiff personally. Second, discretionary objects have standing only in respect of the portion of the trust property from which they might benefit. As their standing flows from their right to secure that portion, they do not have a general right to due administration of the whole trust fund. So far, I have challenged two conventional boundaries in trusts. First, at the theoretical level, I argue that trusts are governance frameworks to support stewardship commitments. On this view, settlors who reserve excessive powers to themselves lack genuine trust commitments. Ying also persuasively pointed out that sham trusts fail for a similar reason of lacking the objective intention to create a true trust. Second, standing should extend to objects of powers in massively discretionary trusts. If I haven't yet sent you to sleep already, let me turn to the livelier question of how trusts might address the challenges of our present century. In particular, how does breaking these two conventional boundaries enhance the trust's capacity to support impact investing? Now, impact investing combines financial returns with social mission. You might wonder, isn't it the role of charity to address social problems? However, charitable efforts are typically remedial, alleviating problems that have already risen, and often as a result of unchecked capitalism. This reactive nature of charity hampers its ability to bring about systematic change in business practices. Indeed, there is something decidedly odd about billionaires establishing a charitable fund to improve climate conditions, whilst their warehouse staff struggle with harsh working conditions. Impact investing, in contrast, charts a different course, addressing social problems at their source by embedding social missions into investment decisions. One might also argue that corporate law provides the most fitting legal framework for impact investing. Indeed, for 7 years, BLAB ANZ had advocated for the introduction of public benefit corporation legislation in Australia, similar to that enacted in many US states. Two leading voices in the debate, this time on opposing sides, were Professor Ian Ramsey and Professor Rosemary Langford of MLS. The proposed legislation, drafted by a working group consisting of Ian, including 3 key features. First, benefit corporations would be required to include a general public benefit purpose in their constitution. Second, directors would have a duty to consider stakeholder interests. And third, shareholders holding at least 5% of voting rights could initiate enforcement proceedings to ensure compliance. The proposed test, the proposal or the proposed legislation ultimately failed, but not because anyone doubted the value of impact investing. Rather, legal reform was seen as unnecessary because existing legislation in Australia already allows corporations to incorporate social purposes into their constitutions. And further, directors pursuing these purposes wouldn't breach their duty of good faith under Section 181 of the Corporations Act. Now, BLAB ANZ then also found a smart way forward. Instead of pushing for legislative change, they now require those who seek B Corp certification to amend their constitutions to incorporate social purposes and stakeholder consideration clauses. Same goal, different path. Australia and Aotearoa New Zealand have since seen some of the fastest growth of B Corps, including renowned brands such as Aesop and Kathmandu. They haven't paid me for the advertisement, by the way. Nonetheless, I must strike a cautionary note. Money has a way of bending corporate social missions over time. You see, a company can amend its articles of association, including its stated objectives, through a special resolution, and that's requiring 75% majority. It may equally choose to accept a takeover bid or wind itself up through such a resolution. What this means, in practice, is that whilst a public benefit corporation and its social mission might theoretically exist in perpetuity, a corporation's actual commitment depends on whether successive generations of voting shareholders remain loyal to that purpose. Perhaps I can illustrate these two challenges with two recent examples. Ben & Jerry's, the ice cream maker and once the poster child of social enterprises, sold to Unilever in 2000, believing it could preserve its activism by maintaining an independent board of directors. After years of tension over Unilever's decision to sell the ice cream in Israel against the board's wishes, Unilever recently, as recent as last week, sacked Ben & Jerry's CEO for doing exactly what the brand was famous for, and that is speaking out on social issues. It actually named social activism as the reason for sacking the CEO. And that's got to do with Trump, really, but that's another story. It is a stark reminder that social missions rarely survive a takeover, no matter how carefully one writes the small print. Another example, OpenAI's trajectory from non-profit to for-profit shows how quickly mission drift can take hold. When it was founded in 2015, OpenAI was carefully structured as a non-profit corporation to develop safe artificial intelligence for humanity. It was then restructured in 2019, 4 years later, to create a capped profit subsidiary, OpenAI Global LLC, to bring in investments, and that's when Microsoft entered the picture. You all know about the boardroom drama about OpenAI in 2023. Following that drama, OpenAI has recently decided to remove control by OpenAI Inc., the nonprofit at the top of the diagram, and established itself as a Delaware nonprofit public benefit corporation. So all it needs to do now is to add in a social purpose in its corporation and write a report every year to say what good it did. The structure is going to be completely different. The reality is, training these AI models is brutally expensive. OpenAI simply cannot raise that kind of money if investors are capped at what they can earn under the current corporate structure. It is a sobering tale of how a non-profit board was ultimately outgunned and outmaneuvered by investors with no legal power, but lots of de facto power. Can trust law overcome these limitations of corporate structures? I think so, at least in principle. This involves breaking down the last boundary by accepting non-charitable purpose trusts. I know that sounds radical to trust lawyers, but please hear me out. Oregon's Stewardship Purpose Trust legislation in 2019 represents a breakthrough in this direction. Its recent adoption by Patagonia, a clothing brand with a long commitment to environmental protection, is worth considering. The Patagonia model uses a dual share structure. The family, which had full ownership of the corporation, transferred all their shares into two entities. The Stewardship Purpose Trust gets and holds the voting shares of the corporation in perpetuity, whilst the non-voting shares were transferred to a social welfare organization developed for devoted to environmental causes. This means that the Purpose Trust, rather than shareholders, controls the operation of Patagonia and directs its future operation, whilst all the profits are directed towards environmental protection. Now, it's key to the success of this structure that the parties of the Purpose Trust stay true to their mission, to the purpose of the trust. And here, the trust structure hold them accountable through two key features. The first is that there's a three-way checks and balance operating between the three parties. First, there's the stewardship committee of at least 3 members directing the trustee. And second, a trustee holding voting rights in the corporation. And third, at least 1 enforcer. Now, all these parties, at least 5 of them, but you can have more, owe fiduciary duties. The committee, the stewardship committee, must report to both the trustee and enforcer, but has power to remove them unless the trust terms say otherwise. And the trustee may reject committee decisions and directions that would breach trust terms or fiduciary duties in a serious manner. So in that sense, all of these parties are bounded by the trust terms and the objectives of the trust. No one is sovereign, and there's a check and balance. And second, to prevent conflict of interest, none of these parties may receive trust distribution. This legislation, drafted in good faith by Professor Susan Gary, a distinguished trust scholar in the US, provides a more rigorous enforcement mechanism than existing non-charitable trusts we see in offshore jurisdictions, such as the Star Trust. I would suggest 2 refinements to make the Oregon model watertight. First, regulatory oversight, similar to that for charities and nonprofits, would prevent possible collusion amongst the minimum of 5 trust parties. And second, stakeholders with a special interest in the trust should be allowed to initiate proceedings, either directly or with the regulator's approval. Now, this second suggestion of allowing stakeholders with a special interest to initiate proceedings might seem radical. However, it actually aligns with often overlooked fundamental principles of trust law. It seems radical because traditionally we have been taught that private express trusts and charitable trusts are distinct institutions with distinct enforcement structures, just like separate mountains that we see here. The enforcement of private trusts was thought to require demonstration of proprietary interests in the trust property, as trusts are, quote, essentially gifts stretched over a plane of time. Charitable trusts benefit the public and are therefore enforceable exclusively by the Attorney General as the state's protective authority. However, once we recognize, as I have argued this evening, that standing in trust law does not need to depend on vested proprietary interest, it becomes clear that the interest of discretionary objects in a private express trust and those objects intended to benefit from a charitable trust are fundamentally connected at the bottom, like mountains. Both groups have an interest in not being unlawfully excluded from trust benefits, whether these are provided in kind or in financial terms. It is clear that, at least in Australia, discretionary objects in private express trusts do have standing. With charitable trusts, courts are understandably more cautious. Concerns of frivolous litigation are heightened due to broader potential classes in these charitable trusts. Equity has not, meaning common law, has not given standing to everyone who may benefit from a charitable trust, and that makes sense. Albeit the Uniform Trust Code in the US and the UK Charities Act and trust legislation in Australian states, except Victoria, do grant standing to those with a special interest or to interested persons. My wonderful colleague in Hong Kong, Jing, an MLS graduate, has conducted a comprehensive survey of Australian courts, of Australian trust statutes on this point. And he observed that Australian courts have interpreted this requirement of special interest strictly to exclude those who are merely morally concerned about trust affairs. However, courts have yet settled on clear principles for determining what counts as a special interest. I propose that the test of special interest should be satisfied by charitable objects belonging to small and defined classes, or by those with a reasonable probability of receiving benefits, such as shortlisted candidates for a scholarship. In such cases, the concern of frivolous litigation is insubstantial. In the US, courts have held that employees of a charitable donors corporation and residents of a small town can satisfy the special interest test. This approach means that we should deny standing to those who only benefit indirectly through the performance of a trust. Who might they be? They might be schools receiving a scholarship holder's fees, or commercial tenants leasing charitable owned property who sue to pursue their own business interests. They're not the intended beneficiaries of these charitable trusts. If a statute recognizing non-charitable purpose trusts grants standing not only to enforcers who may lack sufficient personal motivation to sue, but also to stakeholders who meet the same special interest threshold, it would significantly enhance the accountability of such trusts and open up new ways to structure businesses for impact investing. I now return to where I began. Trust law stands at a critical juncture. It has acquired a bad name in recent years, and it shouldn't be. My thesis is that by reconceptualizing trusts as governance frameworks rather than merely property arrangements, and by enhancing standing rules for the full spectrum of trusts from private to charitable, we can enhance trusts' potential for social impact. Thank you very much for listening.
Thank you very much, Lucina, for that incredibly insightful lecture. Good evening, everyone. My name is Ying Liu. I'm a professor here at the Melbourne Law School, and trust is also my area. And I found this very insightful, and just linking both the theory of trust with the practical developments in the modern day in impact investing. I thought that was great. Now, we have about 10 or 15 minutes for questions. So can I please ask if you have any questions to just raise your hand and wait for the microphone to come to you. And when it does arrive, please just state your name and your question for Lucina, and she'll be happy to answer any questions you have. Michael.
Thank you very much, Lucina, for a magnificent, wide-ranging lecture. I enjoyed it immensely. One issue concerning trusts, which I worry about, concerns broadly drafted exemption clauses purporting to remove fundamental obligations of trusteeship, not excluding conflict of interest provisions, for example. In your scheme of things, is there a way of dealing with these widely drafted exemption clauses?
Yeah, I think so, very Thank you so much for this excellent question. And this is a point that is worth sort of incorporating into this framework, indeed. I definitely think so, especially because I think the idea of trust as a governance framework and trust as stewardship commitment actually means that if you purport to set up a trust, it's not just about writing an instrument and executing it and letting it go, but rather, even for the settlor, making a commitment about it. So if you create a trust and then put in all these exemption clauses for the trustees so that the trustees can actually go about with things and not bear responsibilities, then we are not engaging the core set of obligations, the core set of duties of the trust. But we see that happening, and in fact, sometimes courts fail to, I'm sorry for saying that, and it varies across courts as well. Sometimes courts sort of turn a blind eye and sort of accept them, but some courts are vigilant. And I think really when it comes to holding the trust concepts and ensuring the integrity of the trust concepts, courts play a much more vigilant role than legislatures in this regard. Thank you very much, Michael, for the question.
Simone, just behind.
Simone Degling, University of New South Wales. Thank you, Lucina, for just a wonderful lecture. I have a very basic question. A lot of your scheme rests on what you describe as stewardship, and I realise you only had a short time to explain. Could you tell us what stewardship means in your scheme? Thank you.
Thank you very much, Simone, and another excellent question. Matthew and I actually have written a paper on this, so if you're interested and if anyone is interested, it's a 20-page article recently published in the LQR, so I won't
Sounds
bore
like
you
I need
with
to read
it. The idea of stewardship, really, we were thinking, is that it is the placing of property in a commitment in which the disponent, meaning the settlor, cannot just take away, cannot just end at will. And you are holding the property for long-term purposes, for long-term management. And we think in the article that really the distinct feature of trust is that it enables such types of arrangements much better than other legal forms, such as contracts, fiduciary relationships, or corporations. Because in contracts, yes, there is that commitment and there is that engagement and obligations, but we all know that the promisee, the party to the contract, can always just waive these obligations. Now, the key thing about trusts is that the settlor cannot just say, I changed my mind and I revoke the trust. Of course, yes. I think Jamie wants to say something.
Sorry, I couldn't let that one go. My name is Jamie Glister. I'm from Sydney. Let me add my thanks, Lucina. My question that I was going to ask, and this is why I couldn't let that thing just go, is that argument is very tenable, and you can agree or disagree if you're in what we might very loosely call the Commonwealth law of trusts, but it's not very easy to apply to the United States law of trusts, I don't think, where almost all jurisdictions say that trusts are presumed to be revocable unless presumed to be revocable by the settler unless they're expressly not revocable by the settler, which of course is effectively the opposite from us. So an emphasis on stewardship and settlers can't change their mind and all that kind of stuff, that would seem to be easier to apply to the Commonwealth, by which I include, of course, Ireland and Hong Kong, incorrectly, than it would to the United States.
Yeah. Well, I agree with you. I mean, that's a fair point, but it's very interesting because I think United States is the main place where in the Uniform Trust Codes, they turn it the other way around, and that is that they do not see trust as presumptively irrevocable. However, if you actually look at the drafting of the UTC, David English, who drafted this paper, who drafted the UTC, actually wrote a paper explaining the drafting process. And David was saying in that paper that one reason why they drafted it this way wasn't because the drafters thought that trust concept should be like that. It was unique to the circumstances of the United States, where they used a lot of living trusts, and people were using living trusts as will substitutes. And so the drafting of the UTC was just to reflect the practice of the day, and not so much to say that trust concept should be like that. So I think there's an element of that, and there's a historical background to the US position. Thank you.
Now, conveniently, we have a concentration of trust scholars here. And the next question from Pauline, please.
Pauline Ridge, ANU, and thank you very much, Lucina, for making such difficult concepts really clear for us. It was a wonderful talk. I guess I wanted to push back on the charitable trust and why you don't see, a fundamental reform of charity law as really achieving your objectives, because it seems to me that what you're ending up with is something that's very like an idealised form of a charitable trust, but you seem to reject charitable trust fairly early on as being reactive in character, and I wondered if you could expand on that and why you think charity is sort of a lost cause now.
Thank you, Pauline. There are lots of wonderful questions sort of coming from the audience, and I really enjoyed them. I ought to be careful. I wasn't saying that charity is not good. Charity is doing lots of great work. But the way I see it, charity is not the only way, and may not even be the best way when it comes to solving some of the structural problems in society. Now, some of these structural problems are about the excesses of capitalism, the way businesses run their businesses, the way a lot of social inequality or social issues arise from exploitation of employees. I'm not saying that all entrepreneurs and all wealthy people are like that. So there are some good people. However, if you just deal with it through charity, then I think there's a limit as to how much you can introduce systematic change to business practices. And I mentioned Patagonia partly because they are the forerunner of being a good employer. I didn't have time in the lecture to say a bit more about them, but actually the company itself has a policy of sort of protecting the welfare of the employees, and the owner is somebody who actually doesn't feel comfortable having too much wealth. And what he did, in effect, was to donate his family's wealth to this charitable cause, and also to the trust, and also to be making clothes in such a way that they are also protecting the environment. Now, it's very interesting, and allow me to elaborate on this a bit, because his first successful business was doing something else. He was a very seasoned mountain climber. So his first business was making packs, those packs, and he made a lot of money out of that. But when he realized that those packs actually are bad for the environment because they hurt the rocks, he stopped that completely and changed to making clothes. So I think impact investing allows us to do all those that charitable trusts may not immediately helps us with, or at least it offers another vibrant way to achieve that goal, I think.
Katie? No? You're all right. Okay. Does anyone else have a question? Yes, please.
I hope I can ask a rather more pedestrian question. I'm a retired practitioner, and so I've got time to read. And this is Geoffrey Robertson's book, Who Owns History? It's about the Elgin marbles, and he's trying to develop a legal case for the return of looted cultural objects. And one of the things that's stated and asserted here as part of that case is that on page 55, he's asserting a thief is a trustee of the property. So he's saying essentially A steals from B and holds property on trust. Now, I stopped there and thought, well, that sounds like a load of old tosh. But it's continued on about 4 times in this book. And I started to think, well, even with the Mason High Court and we stretching constructive trust beyond what we thought they were capable of, it still doesn't seem right. And I was wondering if you knew what he was talking about?
Yeah, so this is a wonderful question, And you see there's a lot of laughs coming from the trust lawyers because this is a topic that people have been debating on for ages to no end. Are thieves trustees? The Australian High Court's approach is to basically say, yes, they are, Black and Friedman. The Canadians sort of bought that, but the other courts sort of laughed at this approach. The way I look at it, first of all, I think it's a policy question, ultimately, and that is whether you want to extend the more favourable, more extensive rules of equitable tracing to stolen property. So that's just a policy question. But putting that aside, on the technical front, I think if you actually look at it, the arguments, the technical arguments or the logical arguments for saying that thieves are trustees are just not strong. I mean, the latest was offered by Robert Stevens in his book, The Laws in plural of restitution. Very important to add the S there. In the laws of restitution, so Rob's argument basically is that when a thief receives or when the thief obtains title, what should the thieves do? The thief should return it. And if he has to return it, that means he should not use it for his own personal benefit. And if you cannot use it or should not use it for your own personal benefit, then you are the trustee. So that's Rob's argument. Now, I think the problem with that argument, and that's the latest and one of the better arguments, the problem with that argument is that there's a shift in the meaning of the requirement that you should return it and therefore should not use it. Because yes, thieves ought to return it, but it doesn't mean that the thieves return it as trustees. It could be that he just returns possession of the property rather than hold it as trustee with fiduciary duties and all the rest of it. So I'm not sure if technically we've found the best answer to it yet. And I think really ultimately it's a question of policy whether we just extend the favourable equitable tracing rules. And I think the ideal system is one where we don't mess with trust concepts and we just say whether victims of theft should be entitled to these proprietary protections. And I think they should. Just don't mess with trust law.
Well, you wouldn't want to mess with criminal law either, because if title does pass, I think that upends all of our theft statutes. Anyway, thank you very much. That's made it clear.
Thank you. I hope that helps.
Well, it falls to me to draw the lecture to a close. I'm sure you agree with me that this was an incredibly insightful, very relevant lecture delivered by Lucina. So please join me in thanking her.